Hi, everyone. Welcome to today's live stream legal show. I'm Judy, the YouTube lawyer, and I am licensed only in North Carolina. I handle cases involving employment discrimination, and one of my niche areas of practice is handling federal EEO complaints. So that means equal employment opportunity cases where someone actually works for the federal government. So those cases are handled a little bit differently than regular private employer employees. So I'm going to go down a list. I have prepared a list of my top best tips, whether you're someone who actually works for the federal government and is making an EEO claim, or if you're an attorney thinking about branching out and handling these types of cases. So again, it is a very niche area of practice. I would probably say that it makes up a small percentage of the employment law cases that I do handle. And even in my state, there aren't that many attorneys who specialize in this area. So that's why I hope this video can be helpful to practitioners in the future. So my first tip to everybody out there is a general tip: consult an attorney sooner than later. Don't wait until the last minute when you have a hearing coming up or even a mediation coming up before you think about hiring an attorney. And this is what I see time and time again. People call me up, whether it's a federal EEO case or a regular discrimination Title VII case where somebody says, I got something due within the next month, or I just got my right to sue letter and my deadline to file a lawsuit is coming up in 2 weeks. So why does that tend to happen? Well, first of all, it is hard for most people to find an attorney who specializes in handling plaintiff's side employment law cases. So surprisingly enough, I've actually had referrals from former opposing counsel who work for bigger law firms that only represent the employers. And they get phone calls from regular, Jane and Joe, who has been fired or feels like they're the victim of discrimination, but those law firms can't represent them or decline the representation because of a conflict of interest. So sometimes people do finally find their way to calling an employee side attorney like myself. But if the deadline is coming up so soon for something, especially if you need a lawsuit filed right away, say in less than a month, then chances are likely I would probably just turn down that case because it doesn't give me enough time to be able to read through all of the paperwork and talk to witnesses, get to know the client, and properly draft up a complaint before the deadline expires. So that's tip number one: contact your lawyer or find an attorney as soon as possible. As soon as you feel like maybe something isn't going right at work, or you got passed over for the promotion, or you didn't get the job, or you just got fired, don't delay, because there are certain statute of limitations or certain deadlines that apply. So one thing that some people also don't know is that if you're a federal employee and you feel that you've been the victim of unlawful discrimination, then you really need to complain to your EEO director within 45 days of the alleged discrimination. So I've also talked with some people over the years who, unfortunately, they bring up a lot of things that happened to them many years prior. They feel like they've been the victim of a hostile work environment, or that they got retaliated against, but yet they keep wanting to bring up things that happened to them at work, say like 3 to 5 years beforehand. And so it really mostly is going to be held as irrelevant, especially if there was no documentation of the alleged discriminatory act, you don't have any witnesses, and most importantly, you never complained to the EEO office for your agency within 45 days of that alleged discriminatory act. So another lesson there: don't delay. The second bit of advice I'd like to give to anyone out there who's watching is that many times employees sink their own cases by focusing on legally irrelevant issues. So that really sinks your case if all the employee can do is keep complaining about how this person was treating this other employee differently because he was having an affair with her, or she only would let her friends go out to lunch or have longer lunches, and I don't like that because I'm not part of the inner circle of friends. Well, once again, that is not illegal. This happens all the time in any sort of workplace where an employee can feel that other people are given preferential treatment or that they are not being treated with the same respect as other employees. But unless you have proof that it was based on a protected factor, such as national origin, race, color, sex, sexual orientation is also included, disability, religion. So those are the protected factors. Just because they don't like you, that again is not an illegal reason to be treated differently. So the more the employee continues to hammer on the fact that, oh, just didn't like me from the start, or yeah, he always treated this other woman better, or I get the feeling that she never liked me and she just wanted to do favors for her own friends. Well, that again means that you most likely are not going to be having a legally valid case under the Civil Rights Act. So along the same lines, if the person's complaint is more rooted in problems that involve the union or workers' comp case, I've seen some cases fail in that respect and get thrown out on a motion for a summary judgment because, once again, the court or the administrative law court feels that it is improper for them to have jurisdiction, or they just don't have jurisdiction to deal with issues that have to do chiefly with someone's workers' comp injury. That's not what they're there for, or for any problems that the person might be having with the union, even if it is retaliation or alleged retaliation based on union activities. So that is not what the EEO process is there to remedy. So unfortunately, I've had to explain that to some clients. Okay, so third best tip, very important thing that you really want to watch out for as an attorney as well as an employee with a potential EEO claim, is that you got to read through your initial order that is signed by the administrative law judge. So sometimes these things are titled differently, but it is normally a document about 6 pages long that is generated after your case gets assigned or assigned to an administrative law judge. So usually has a pretty long name. I think sometimes people just call it the acknowledgement and scheduling order. Other times it could say notice of receipt of hearing request, order to produce report of investigation, order to forward notice of representative, and order scheduling initial conference. So in this document that the employee or his or her attorney would receive by mail, the most important thing that I would draw your attention to would be the deadlines for initiating discovery. So discovery means that each side has the opportunity to take depositions or send out interrogatories or requests for production of documents. And that's so important because in every single EEO case, you know for sure that the agency's attorney is going to be making a motion for a decision without a hearing, which is also known as a motion for summary judgment. And the only way you can combat that is by citing to affidavits or your report of investigation, whatever could be contained therein, or any discovery responses that you could have gotten. And I know for sure that the EEOC is very much a stickler for the deadlines. So if you fail to initiate the initial discovery or start sending out your discovery requests within that 20-day deadline, then too bad. They're not going to feel sorry for someone who comes crying and says, "Oh, I couldn't find an attorney until now. Let me send out some interrogatories or requests for admissions." Basically, you're toast. So, you can still potentially go on forward with your case, not having done any discovery on your own behalf. but it makes it even harder for any attorney later on to try to salvage your case if you're not allowed to send out any discovery to the agency to respond to. So that's what I think is very, very important. I've seen it over and over again where somebody tries to get lenience from the administrative law judge because they didn't have time to get an attorney or couldn't find an attorney until the deadline has passed. But it doesn't matter. You got to stick to that 20-day deadline to start your discovery. So let's see. Another great tip that I have would be to make sure that you get affidavits from witnesses as soon as possible. These types of cases tend to drag on for years and years. And by then, a lot of potential witnesses may have already forgotten what they supposedly witnessed for your case, or they can't be found if the person no longer works there, or you don't have a good phone number or a good email address to contact your so-called great star witness. Well, there goes your case, because you don't have any right to subpoena people to show up to the EEOC hearing, if you even get to an EEOC hearing in your case. So that's actually part of the investigatory process, though. Typically, when your case gets assigned to an EEO investigator, they will ask the employee who are the relevant actors or who are the relevant witnesses for your case. And then the employee would give a bunch of names and information and stuff, typically coworkers or names of management, people within agency. And the investigator is supposed to send a questionnaire, which the person would then hopefully respond to. Although I've been involved in a lot of cases where the person just refuses to respond to the questions, or just gives very, very brief little answers that don't support the person's case at all. So even if the ROI, the report of investigation, has these kind of like scanty, kind of shoddy responses from your witnesses, later on, you could still try to get better affidavits from your witnesses. And this is what's frustrating, because a lot of times people are concerned about retaliation, even though technically they're not supposed to be retaliated against for being involved in someone else's EEO case, but we all know it happens. So if you are able to get witnesses who are willing to write affidavits about what they witnessed and what they would say to support your case, that would be really, really valuable. And it's something you can still do even if the person did not fill out a questionnaire, or, oops, the employee forgot to mention it to the EEO investigator. There's still some time to get that affidavit done before the motion for summary judgment is filed by the agency's attorney. So my other tip is that you have to be very, very patient. Nothing is ever going to happen quickly in this process. So when an employee first initially contacts the EEO office to complain about discrimination or feeling discriminated against, the EEO person is supposed to do an investigation and try to work things out first. That's always the first step, is to see if alternative dispute resolution can be a way to resolve things. But I would say in all of my clients' cases, that was kind of useless. They felt like the people that worked for the EEO office within their own agency were sort of biased, or just kind of brushed off their complaints, and basically took the management side, which, I understand sometimes the management does have legitimate reasons for what they did, and sometimes people do file frivolous EEO cases or complaints also. So the alternative dispute resolution, normally they want to bring everybody together in a more casual, informal way to see how they can resolve things. But in my experience, it's probably because the people who contact attorneys are the ones that have already gone so far and know that there's no way they're going to resolve things. So usually it doesn't work out. But then after that, once you do have the right to request a hearing in front of an administrative law judge, that's when this huge period of waiting that could be 3 or 4 years is going to just drag on forever. And this is the reason why in part, there aren't that many attorneys that handle these kinds of federal EEO cases. I even spoke with an employment law attorney in my state who said he doesn't take on these types of federal employee cases anymore because of the fact that it would take years and years of waiting. Nothing would happen on a case, and then bam, you get a notice either in the mail or notification through email saying that something's due soon, or you're getting ready to have a EEOC hearing in a month or whatever. So it really doesn't give the attorneys much time to prepare, and you always kind of have to feel like you're on standby because you never know when something is going to jump out at you, and then suddenly the case is active again, or you have to set aside time in your schedule to show up for a hearing or prepare a brief. So all right, so another example I can mention is that I once represented an African-American man who had been sexually harassed by his white female supervisor for a federal agency. So this dragged on so long. We got through the motion for summary judgment, and then we waited and waited and waited for more than a year before we finally started talking about scheduling a hearing. And by the time of the hearing, this was actually a good thing that there was so much delay, because by the time of the hearing, 2 of my client's star witnesses no longer worked for that federal agency anymore, but they were still mad about what happened to my client. So they were willing to voluntarily show up to the hearing and tell the judge everything that they knew about the situation. And also by then, we're talking about 4 years after the alleged discriminatory acts or retaliation happened. 4 years later, when we finally sit down and had this hearing, the alleged wrongdoer wasn't even working there either and didn't show up to the hearing. So that made my job a lot easier, plus the fact that the witnesses no longer feared retaliation because they weren't even working there anymore. So that made the case a real winner. So in a way, it kind of stinks that people have to wait so long before they can finally get resolution or finally win their case, especially if the agency is making a lowball settlement offer. And we'll get into that soon. But then on the other hand, the positive things are that by the time the hearing takes place, maybe some of these great witnesses will be more willing to testify on behalf of the employee because they are no longer working there and don't have to worry about being retaliated against, which is always people's fear. They really want to keep their jobs. They have a nice federal government job with benefits, and that's why it's so hard to get other coworkers who are willing to be witnesses for these cases. So getting to the point of settlement. So we always hope that cases will settle. In the private sector or in the regular court system, my experience has been that meritorious employment cases almost always settle before you get anywhere close to trial. So a lot of private employers, for whatever reasons, due to the high cost of litigation, the disruption to their normal operations, management having to get involved with court proceedings and depositions, not to mention a negative publicity. So they all have that incentive to want to settle their employment discrimination cases quickly and quietly. However, that is totally not the case when you're dealing with the federal government. So in the federal EEO cases, it's the complete opposite, where they have no incentive to give the employee a nice settlement. In fact, I would say the vast majority of the times, the agency attorney will tell me that they're offering nothing for a settlement. What else can you say? It's like, okay, you offer nothing, then we'll continue with this case, and maybe we'll surpass the motion for summary judgment, and maybe we'll get to a hearing in 3 or 4 years. Okay, great. So it completely is kind of like lopsided, where the employee or the former employee may be really suffering if they can't find another job, or they haven't been able to find another job that pays as well, but yet they have to wait years before they get their day. It's not really in court, but a hearing in front of an administrative law EEOC judge. Another reason that they don't want to settle is because there are already attorneys that work for these federal agencies that handle all of these EEO type claims. So, it doesn't cost them anything. It's not like they're hiring some outside counsel that's some high-priced big law firm charging them by the hour. Rather, there are federal government attorneys that do these kind of cases and defend the agencies. So again, no incentive for them to offer much of a settlement. I've had some cases where maybe they'll offer, a very piddly low amount that is nowhere near what my client's actual financial damages have been. There was one case where an agency offered somewhat plausible or somewhat decent settlement amount, but the client did not want it because she had felt so discriminated and retaliated against. So once that case went all the way through a hearing, we were actually able to get many times more as the judgment entered by the judge. So that turned out to be a good case, but it is very rare that they are going to offer any sort of settlement or any slightly decent settlement amount for these federal EEO cases. So hi, Tony, thanks for being here. I appreciate your support. Yeah, so this is definitely a more serious topic, but I do feel like for some practitioners or for, say, some law students who might be interested in employment law, this is an important niche practice area of employment law that I think we need more attorneys trained to know how to handle these cases, especially for the employees, because I feel like it's just myself and one sort of elderly attorney in the area who has significant experience handling these types of cases for federal employees. And then further out in Charlotte, there's maybe one or two attorneys that I think also have had experience dealing with these types of cases. So it's kind of sad to think that, okay, well, once these older attorneys retire, are there any younger attorneys out there that have the experience or even have a clue as to how to handle these cases? Yeah. So originally I wanted to flash up some documents on the screen, but I don't think that's a good idea because of confidentiality issues. And I'm afraid that, for example, the client's name might accidentally show up on the screen, and that wouldn't be a good thing. So instead, I'll just go ahead and mention some quotes from other cases that would sort of be good to mention. So let's say your client is alleging that they were discriminated based on disability. Well, always remember the first thing you have to prove is that the client actually does have a disability. Okay, so once again, there are times when people come to me and they're complaining about being mistreated or retaliated against, but then it turns out it was also because they had a workers' compensation injury. And I've seen it time and time again where the EEOC judge will then later say, well, we don't have any jurisdiction over this stuff. This all has to do with workers' comp or workers' comp alleged retaliation. It has nothing to do with Title VII of the Civil Rights Act. So you do have to be very careful if the client comes to you and they're talking about, first I got hurt on the job and then they started retaliating against me or demanding that I give all these like additional medical documentation, or my manager started harassing me and not letting me have time off so I could see my doctors after my on-the-job injury. So, the court wants to emphasize that an on-the-job injury is not in itself a, quote, disability within the meaning of the Rehabilitation Act. So if it's just like a temporary injury rather than a real disability within the meaning of the Rehabilitation Act, then that doesn't count. Yeah. So another thing that you often hear potential clients coming to you about is, just general mistreatment, like this wasn't fair, this person is mean, the manager's so rude to me, the supervisor was like letting his friends bring food into the workplace, or, he lets his friends get away with this and that. So again, you can't really just use that to bolster any sort of valid discrimination case, because there's been plenty of case law which repeatedly says that the court is not going to be in the business of mandating civility amongst the workplace, that there's a general amount of rudeness or crudeness that people are expected to put up with within the workplace. And just because somebody said something mean to you or made a stray comment here or there, that wasn't anything that would be actionable because it offended you. In terms of just general hostile work environment or harassment, you also have to be able to prove that it was, quote, sufficiently severe or pervasive to alter the terms of employment. So this is where it gets really, really hard to prove. And sometimes you have to be the bad guy who just gives the bad news to your potential client, that whatever they experienced on the job, whatever rudeness or mean behavior from the coworker or the supervisor being mean or having favorites, that's not bad enough. You still have to show that it was based on your protected characteristic and that it was sufficiently severe or pervasive to alter the terms of employment. So that's another thing, is that you also have to show, in some cases, you have to show that there was actually an adverse employment action. So usually it would mean that the person got fired, but it can also mean that the person did not get a promotion, didn't get a raise, had their pay cut. So I've been involved in cases where that was the issue, where the person still had a job, but her hours were severely cut and she was given worse tasks to do as a result of telling her supervisor that she was going to complain to the EEO office. So you have to watch out for that also. If there was really no adverse employment action, then it's like, okay, well, so what are you trying to claim here then? Hostile work environment? It has to be really, really bad in order to even qualify as a hostile work environment. Otherwise, everybody would be complaining and filing EEO charges. Yeah. Oh, hi, Phoenix. Thank you for being here. You're a law student, right? Okay. Can an EEOC administrative case be filed in district court if there is no activity or an appeal? Yeah, there are many steps, and you can definitely take it further to federal court also. But by and large, with these federal employee cases, we typically just stick within the EEOC realm. And if we lose at a hearing, then the person still has the right to appeal to the EEOC. But I've done a couple of those cases, but I would say it was kind of like a 50-50 chance of being successful on appeal. And those were cases that I thought were worthy of appealing because from a business standpoint, I don't handle these cases on a purely contingency fee basis. And so people actually do have to pay for an attorney. I'm not sure how other law firms or other lawyers handled that, but as far as I know, I don't know of any employment discrimination plaintiff's attorney that does things purely on a contingency fee basis. Usually, at the very least, they would expect some money upfront as a flat fee plus partial contingency. So, I mean, while it's true that you could potentially get your attorney's fees and costs awarded back to you, that's only after assuming you win the case and assuming that the agency doesn't appeal the case. So, from an economic standpoint, it just makes it incredibly hard for any attorney to just do these types of cases that can drag out for more than 3 or 4 years on a purely contingency fee basis. Yeah. So if anybody has any other questions, feel free to drop it in the chat box now, or else leave it as a comment on the video later on. Again, I do feel kind of bad that there aren't that many attorneys that handle these types of employment discrimination cases for federal employees. And I mean, I don't even know of any younger attorneys that are interested in this field or are starting to learn and practice in these areas. Once in a blue moon, I do hear about continuing legal ed opportunities to teach attorneys about how to practice this area of law. It can be potentially very lucrative, and it's a great feeling if you do get to settle some of your clients' cases or you win your case at hearing. It's such a wonderful feeling to be able to help an employee who genuinely was discriminated against or retaliated against or fired wrongfully. So it could be like a good practice area to get into. So thank you all for being here today. I know it's kind of an unusual time because most of my live stream shows are on the weekend or in the evenings. So, I see Serena is here. Thank you. Thanks for joining in. Do you know why it is that people don't really practice in this area? Yeah, I would say what I mentioned earlier was this one attorney who I would say he's one of the younger employment law attorneys who does plaintiffs work in general, but he told me he doesn't want to do these federal employee cases because they drag on forever. And then, bam, it jumps back out at you whenever something finally happens, with a hearing getting scheduled, or finally a judge finally made a ruling on a motion for summary judgment, which could be 2 or 3 years after you already filed your initial brief. And then suddenly you have to jump on the case. So what if you have a bunch of other clients by then, and you already have other court hearings and other client matters that have already been scheduled? Then it becomes like a total, a very stressful situation when you suddenly have this kind of case jump out at you years later after being dormant. Yeah. Another thing is that a lot of these cases are hard to win. So you end up meeting or talking with lots of people that get kind of upset, even with the attorney, when you tell them they don't have a good case, and you have to explain to them why, I'm sorry this happened to you at your job, but this isn't a legally valid claim, or I don't think this is a case that you're going to be able to win. So I don't think you should even waste money trying to hire an attorney to do this type of case. So I've had other attorneys that did some employment law who told me they just kind of got tired of constantly meeting with people who were mad about their workplace in general and complaining, and yet he had to just keep telling them, you don't have a case, you don't have a case, this isn't discrimination under the law. So because I think the general public thinks that you can just sue for anything just because you feel harassed in general at your workplace, or you feel discriminated against, or you're mad because you got fired. So, but in general, that's not the way the law works. And so it can be frustrating that way, not to mention the fact that many people, they just don't want to pay the attorney, or they say they don't have any money to pay the attorney because they got fired or laid off. So that's a sad thing of it. Yeah. Do state or federal employees or contractors potentially have more EEOC protections than private people do? I don't know. Well, I wouldn't say EEOC protections, but there's the Merit Systems Protection Board, and they do have unions that give them another totally different avenue. So that's why oftentimes you hear that it's really hard to fire federal employees or fire postal workers, because they have a very strong union that allows them to just keep grieving or filing grievances if they don't agree. And many times, even if they might be picked for removal, or they're about ready to get fired, then they can have that overturned by having some sort of union type of dispute. What about gig workers? Oh, yeah. I mean, if you're like a gig worker or you're an independent contractor, then you basically don't have employment rights because you're not deemed to be an actual employee. You're just a contractor. So, but then there's also been cases that hinge on whether the person really was an independent contractor versus being a real employee that should have had employment rights. So just a general practice tip is that you do have to ask in general, the potential employment client, were you an actual employee, and who was your actual employer? Because sometimes people have come to me and I talk to them a little bit more, then it turns out that even though they worked at this company, they were not actually employed by the company. Instead, they were contracted by, say, like one of those like temp agencies or some sort of go-between intermediary company. So, the person could potentially not have rights against the actual company that they worked at because they were not employed by that person or by that entity. So there are just like so many layers of employment law and employment discrimination law that, it can get mind-boggling at times, but that's what also keeps it a very interesting practice area. Yeah. So, okay, I think I'll end it here. It's just a little over half an hour. Hope you guys will join in on Friday night, 7:45 Eastern time, when Nathan Fox, a master professional LSAT instructor who is the head of Fox LSAT. He also co-produces the Thinking LSAT YouTube channel and podcast. He's going to be my special guest on Friday night. So I hope you guys will be there. Have a great day. Thank you.